Peter, would you allow me to ask more questions?
Okay, far away. I'm Peter Mallett, and I've been around the industry for more years than I care to remember. Quite often, a contract will provide a definition of what a claim is and what a variation is.
Hello everyone, I am Mohammad Tanveer Khurshid. I am going to present you the partial video recording of online session on construction contract variations and claims with Peter Mallett, which was held under the aegis of Project Professional on 18 June 2021. A brief on Peter. He has over 30 years of international experience in energy, LNG supertrains, refinery and process installations, power plants, pharmaceuticals, and offshore installations. Currently, he is working as Director in Triangle Contract Associates Limited, UK. The recording comprises part from his presentation and part from the questions and answer sessions.
Well, good afternoon, everybody who's joining us. First of all, let's have the commercial. I'm Peter Mallett, and I've been around the industry for more years than I care to remember. I've worked for most of the major engineering and construction companies issues and developed strategies with the defendant, if you like. And then we try and provide solutions to help with reducing those claim opportunities. Can I suggest that we all mute except for me, and then at the end we can have a question and answer session.
Yeah, sure. Peter, we'll all mute, and first you will have the presentation, and later we can have an open floor for any questions that you will take it.
Absolutely. I mean, if necessary, you can always ping. Sorry. Yeah. If necessary, you can always ping, and we'll try and answer any questions that come up during the display. So, moving on then, well, what are contract variations and what are contract claims? Quite often, a contract will provide a definition of what a claim is and what a variation is. But in essence, variations are permitted instructions. In other words, the contract will say, if the client wants to add work or even deduct work or revise a drawing, etc., those may be considered a contractual claim. Sorry, a contractual variation, and they would go through the normal variation process. But there are two types of claims. Claims arise when an employer action, what we call in English law an act of prevention, occurs. Now that can be anything. That can be where the client has failed to operate an extension of time clause, or it could be there's no extension of time clause in the contract, which I've experienced previously. And so when variations occur that are legitimate and they attract time, there is no means of actually adjusting the contract time to cope with it. So that's a contractual claim. An extra contractual claim would arise where there's a breach of contract, and in those cases a breach of contract might be failure to pay.
Hello, Peter.
Hey, how are you?
I have one question. Okay, I'm Bashir Alam, an electrical engineer. My question is that when variation comes in project, okay, it comes with a chaos, means chaos between contractor and main company. So I'd like to know what is the best method for requesting variation claims. If variation has come, okay. So
Yeah.
for contractor, what is the best method for requesting variation in claims?
Right. Well, going back to that's kind of two questions. Let's see if
You
I
are
can
getting,
share.
you
Yeah,
are
yeah.
getting my point.
Yeah. Let me. Can I share my screen again, please? I'm trying to. Okay. Well, look. Going back to what I said about the difference between a variation and a claim. There are very many ways that you can start the conversation. You can be in a meeting. Can you hear me?
Yeah.
Yeah, you can be in a meeting and you can put it on the minutes. But minutes of meetings are not generally a notice.
Okay.
You can put it in your monthly report, but again, it's not going to be a notice. The only way you can, in most contracts, and again, it depends on your contract, but I've not seen any that differ from this. The only way that a contractor can apply for a variation is to submit a notice in accordance with the contract. And if you recall, I showed you the FIDIC timeline. That is the only way you do it. And the one thing that you must do with notices is, first of all, they've got to be headed up and easily identifiable as a notice. So your title to your letter is notice of claim under clause such and such, notice of variation under clause such and such. It's got to be sent to the correct address. A lot of contracts have different addresses for administration, but they will have a certain representative named. And that named representative must be at an address, and you must send that notice addressed to that representative at the correct address. If those three things aren't there, or one of those three things aren't there, and you go to court on it at a later date, you will fail under English law and in fact under the civil code of the UAE, you will fail as well because you won't have complied with what the contract says.
But the thing is that before going to court, should contractor stop the work for being given notice?
No, never stop the work.
Okay.
If you stop the work, you actually breach the contract.
Telling regularly, he's doing all the things. He's submitting all the applications.
Yeah.
He's not getting noticed. Okay. And the thing is that he wants, for all these things, he wanted to stop the work, but that is not okay. And
no, you can't stop the work.
Okay.
Yeah, you can't. If you stop the work, the wording is always in the contract. If you stop the work, you effectively breach your contract. And if you breach your contract, the contract falls away. There's no arbitration. You go straight to court, and then and then the client or the contractor goes for damages, depending who's breached the contract. So, a major breach of contract is a failure to continue the work. But again, you see, are you the contractor or are you the client in this scenario?
I'm client. I'm not contractor.
Right. Okay. So you're the client.
Usually, I have seen from my contractor side.
Okay, we've done it from both sides. We all do. But in this instance, my advice would be to look for the win-win again.
Okay.
Because if the contractor is struggling that much, even if he hasn't issued a notice, you know that he's got a problem, and that, if you got into an arbitration, would weigh heavily against you. Because the one thing that came out of a recent, it's a 2017 case under English law, was it was an aside that the judge stated, but nonetheless, what he said was that the rules around notices, because notices normally time out. They have if If you miss your 14-day window, then then effectively you can't issue the notice. But what he said was that if there is a legitimate claim, the notice provisions shouldn't be used against the contractor.
Okay.
So if the contractor has a legitimate claim and hasn't operated the contract, it's up to you in a win-win situation to try and help them. That doesn't mean to say you pay them more money. It might mean you give them more time. But you've got to find some way of solving the problem, not just ignoring it. So if the contractor's coming to you and saying he's got a problem and he hasn't issued a notice, you can always go back to him and say, well, the contract says you should have issued that notice within a certain amount of time. You failed. But if he then says, well, I haven't, whatever it is, competence or incompetence, whatever, if he says, I have still got this ongoing problem, then strictly speaking, I'd expect you to get involved and say, well, okay, what's the problem? How do we solve it? But that's a management job.
Yeah. Peter, usually what I have seen, all these things come at the mid of the project. Okay. Chaos between contractor and client. And due to this, project got deaccelerated. Okay. So my another question is that for the acceleration and mitigation of project delays, what we can do at the starting of the project for client and contract, both, I'm asking you.
Well, that's exactly what I went through earlier on. And I said, and I did say that there are all sorts of things that you can consider. But if you look at the slides, which I'll issue on the WhatsApp group, but if you look at the slides, it has a whole list of things that you've got to look at when you sign a contract or when you start a contract. One of the things is educating the team. The other is making sure that you've got a risk profile. You've really got to start that risk profile right from the beginning. So, it's not just about money. It's about what can happen and what's the likelihood. And then you go through the project and you mitigate those risks as you go. And you will add risks and you will remove risks. But that's how you manage that particular issue that you got. And that's how you manage the relationship. Because if you don't manage that relationship, you have what you call chaos. So that to me is what I would recommend. So if you have a look at the slide, the slides lists are not definitive. There are many other things you can add in, but for an example and a starter, that's what you've got. Okay, no problem.
Okay. So, Peter, would you allow me to ask more questions?
Okay, fire away.
Okay. And but in the meantime, other people also prepare your question and ask me. Okay. Once I finish it, because I have many questions with you. Peter, this what I have seen that there are clauses. When I will talk about the oil and gas contracts only. And one more thing is that these contracts what I have come across where I have worked, they do not follow the FIDIC model.
Right.
Yeah, they are not following the FIDIC model. And each of the company, they have their own contract model for different types of contract.
Yeah.
Okay. So, and generally in the EPC contract, what I have seen that they give that, okay, these are the hierarchy of precedence. Yeah. But when they go to any drawing or anything, they refer to some codes or some, so they have some reference. But they say that the most stringent will prevail or will be followed.
Yeah.
Okay? Who will decide most stringent?
Right. It's what you'll normally find, and you're talking about bespoke contracts, but what you'll normally find in these bespoke contracts is a statement that there is a required level of quality, which will be best industry practice, good international practice, etc. Now, these are all terms that can, if you Google them, you'll find what they mean. But quite often, and in fact, the last job I did in Albania, we had a statement to the effect that the contractor would use best industry practice, and then we defined what that meant. So we said best industry practice was, and it was a grade of work that, you know, that would be seen as better than other projects of a similar type and size. I can't remember the exact words, but once you've set that standard, everything has to work to it. And if there is a contradiction in the contract, so you'll say conditions, scope of work, drawings, pricing, etc., and that's your hierarchy. If and this is under English law, if you, let's say you're doing a refinery job, and in the tank farm you've got to build a 10,000 gallon or 10 million gallon tank, and that tank must have a floating roof. So in the scope of work, which is just below your contract conditions, it says you will build that tank to this standard, etc., etc. It must have a floating roof. But then you go to a supplementary document, for instance, the tank specification. And the tank specification specifies a static roof. You've then got to say to yourself, what's my hierarchy of documents? Because there's a contradiction. And if you want to apply the specification, you've got to pay a variation, because that specification, it's called contra proferentum under English law. That specification means that the contractor, because of the hierarchy, the contractor would have, I've got this round the wrong way, would have priced a solid roof, but your scope of work says it must be a floating roof. So he's got the specification that says solid roof, and he would have priced that. But and even if you sign the contract and it says it's the entire agreement, you've now got contra proferentum in it. And because you've drafted the contract, it's a bespoke contract. This wouldn't happen with FIDIC. But because it's a bespoke contract, under the rules of contra proferentum, the contract must be read in favour of the contractor. So the drafter fails. So in other words, you've written that contract, you knew what was in it, it's going to cost you money to do it right. Sorry, you got it wrong.
On that point again, the most stringent will apply. I've been reviewing some offshore wind contracts, and there's a lot of statements about good offshore wind industry practice will apply. But it's an immature industry.
Well, it doesn't matter, does it? Because you've got standards and specifications. There's a big problem with the offshore industry at the moment, and that's called monopiles.
Yeah, yeah.
There's cases coming to court now whereby, because as I understand it, what happens is these monopiles are driven in to a maximum of 30 meters, I think it is, but they're only designed to 20 meters, and they've been driven into a maximum of 30 meters, and now they're failing. For those who don't know, a monopile is basically a great big tube, steel tube, with a flange at the top of it, and that flange then gets a windmill tower bolted to the top of it. And what's happening is they're driving them so hard they are cracking or putting the flange under strain, and then they're failing. So it's quite an interesting thing. But David, the answer to your question is that if you've got standards in there, and somebody isn't following them, they're not operating the best industry practice, are they?
Yeah, but they do seem to be relying on this phrase quite, in the drafting of the contract. It was quite prominent. I thought.
Why not? I mean, we all do, and then you'll end up having hundreds of arguments about what it really means. Yeah. But have you got best endeavours in the contract?
Well, they're NEC based, but then there's a whole bunch of.
Yeah. If it's NEC based, it'll have best endeavours, and it will also have fitness for purpose.
I shall have a check on that.
Yeah, you need to look at fitness for purpose, because if it says fitness for the purpose to be derived from the contract, then you go back to the specifications. If it says fit for purpose, full stop, then you've got such a broad requirement, you're almost into gold plating. And if you've also got best endeavours, and this is one for everybody, best endeavours is a standard that is so high, legally you are to comply with it, you are required to even put yourself into commercial difficulties to carry out the work. So never ever sign a contract with best endeavours in it.
Okay.
Reasonable endeavours are good, best endeavours, no. And in fact, that's the argument that's just happened with AstraZeneca and the EU. Because their contract said reasonable endeavours or something like that to deliver, and the EU said that they should be using their best endeavours, and that's why that's why that court case has just failed today.
The other one I had was your slide on scope creep. Whose responsibility is that to identify?
Everybody's. That's why you read your monthly report.
Because you as the client if you want to get the job done, but do you give your contractor a helping hand when they're not up to doing it?
Well, if the contractor's not up to doing it, why have you employed them?
Well, yeah, so there's always that argument, but you're stuck with the contractor for the minute, so you need to do the work.
Exactly.
So
and the contractor has an obligation to complete the work. It has a contract between the parties is an agreement to carry out work in return for money.
Yeah.
That's what it is. And when you buy a contract, you buy a schedule. So if the work's happening on time, in due time, then you've got no problems. But if there is a problem in that you've priced, the contractor's underpriced the work because you told him to. In other words, you kept going back to him and saying, I want another 10% off, which I've seen done many a time. Then you've bought the problem, and that should be high on your risk profile. When you start the job, you've done your risk profile and you say inadequate pricing, and you budget for that failure. If you don't do that, then you're going to go down this route of, well, we've got a problem. 6 months from the end of the job, nobody can do the job because he's run out of money. And the best will in the world, you probably bankrupted him. So even if you took him to court, you're not going to get your money back. So the real answer is when you pre-qualify these contractors and when you tender the work, the price should be the third criteria. The first criteria is schedule. The second criteria, scheduling resources. The second criteria is capability and safety, and the third criteria is price.
Yeah.
Any other way, and you've lost the plot, in my opinion.
Not management's opinion. Yeah.
Well, no. hey, it's our job to lead
Educate the
management
management. Yeah.
and educate them. Yes, that's why I said in that slide, educate them. Tell them what the problems are. They can always say they don't agree with you. But has anybody ever met a project manager that who says he likes his contract? I've never met a project manager who's been happy with the contract. And the number of times that I've had to stop people making amendments to contracts because they didn't like it. Well, you had your opportunity before award. If nobody listened to you then, they're not going to listen to you now. Anyway, did that help?
Yeah. But that's one of the things that you're saying project managers always want to change. They should be involved in the bidding stage or the tendering stage.
Well, I'm surprised they're not. They usually are.
Not. Yeah, sometimes not. Yeah, I suppose they
Most
are nowadays.
likely, the project managers are not involved during the bidding most of the time. They get on hold when the project is awarded. During the
okay. Yeah, it does depend on the circumstances. And of course, you may not have a project manager appointed by the time you're bidding the job. But in my experience,
he's handling some other project that time. By the time he finishes, the new contract gets awarded, then he shifts to the new contract. That is what it happens generally. Yeah.
Well, and of course, haven't we all been in circumstances where we've been working on one project and then said, oh, well, the new project over there, off you go, and you find that you arrive 3 days after they've awarded it. And so you can't influence what the contract says. And the number of times that I've sat down and said, I hate this contract is it's probably 20 times over the 41 years I've been doing it, So what you've got to do is you've got to manage your situation, and you've got to, variations and claims are just bread and butter to us, and you try and minimise them. And to do that, you've got to do your risk profile. Get that done right at the beginning. You and as part of the project controls team, get together and get your risk profile sorted out on your risk register. Have it on the wall and tick off every week when you've solved one of the risks, or when you've added one on, show it and highlight it and say what the solution is. Not always easy, but it does make it interesting.
Yeah.
Okay.
This is Shiroz.
Hi, Shiroz.
When we are responding to the contractor's claim, so what and all we have to include other than the contract clause and all that? Is there any standard format which we see these and all should be the things which you have to include for the response to the contractor's claim? Is there any standard format or something?
Well, that would depend on what your contract says to an extent. You need to look and see if there are any restrictions in the contract. But I always think it's wise, even if you've got 20 days, I always think it's wise to respond to a notice of claim. And I would say that what you do is you include within there, within that letter, yes, we've received your claim reference such and such on such and such a date. We have until such and such a time to confirm whether we consider it legitimate or not. And we will review that. But in the meantime, we accept no liability for any claims or changes at this time. Words to that effect. So what you're saying is, yes, we've got it. Yes, we are going to look at it. But no, we don't accept it as legitimate at the moment.
Okay.
Then and if you're using FIDIC and you're on that kind of timeline, then those timelines can change. Then when you go at the end of your 14 days, you can either say, yes, we reviewed it, thank you very much, but it's not valid and this is why. Or, yes, we reviewed it, we consider you to have a valid claim, although we do not agree the impact. So then what you've done is you've gone back, you've met your obligations under there, and you've given the contractor the opportunity to either continue submitting his updated changes or updated notices, or he can withdraw if you say that it's not legitimate, or he'll go into this dispute mode. Now, you've got to be careful because you can't just say no. You've got to give really good reasons for saying no, but you don't have to give good reasons for saying yes.
Is it required we have to answer each and every concern the contractor has raised in that letter, that we have to close everything, or a general thing will be, even if it is not legitimate and all that, also we have to close everything what the contractor is
yes, you do.
For?
If you're rejecting it, you have to go through it line by line. And in another presentation that I do, I talk about correspondence. And what I would say is that if you've got a letter there that's got 20 different items on it, you send it back to him and say, sorry, we can't deal with this. One letter, one issue. Because if you've got to answer 20 different claims on one letter, then I'm afraid you're going to be there forever and a day, and you run the risk of not covering the right things. So again, when you start your jobs, your contract administration rules should be one issue, one letter.
Okay. But the contractor has raised various issues in one claim itself, like wastage of manpower and lack of work front. And there are so many other 3-4 issues they have raised in the same claim itself. So
yeah, but I mean, if it's a disruption claim, it'll be one issue, but it's got many different facets. Yes, you know, if you agree with it, you're going to have to address every item. Or sorry, if you disagree with it, you're going to have to address every item. If you agree with it, you can say, okay, fine, let's plan the way we're going to solve it, which may be you have a series of meetings.
Okay. Thank you very much.